Hi all and welcome to our channel. We often get inquiries from visa holders who are either arrived in Australia on a prospective marriage or 309 visa or hold a temporary partner subclass 820 visa with the distracting news that a relationship has broken down and unsure what steps to take in respect to their immigration status. Often the relationship has broken down due to family violence. Be aware that family violence is not acceptable in Australia. If you or a family member have experienced family violence, you and your family do not have to stay in a violent relationship to stay in Australia. My name is Willem Oostdijk. I represent Oley & Associates, a pioneer and global leader in migration and education services since 2002. In today's video, I discuss and explain what is meant by the family violence provisions and when and how the family violence provisions apply to partner visas. Don't forget to subscribe to our channel, and for any questions you can email me directly at willem@oley.com.au. So what is meant by family violence under the family violence provisions? Family violence is any behavior that makes you reasonably fear for your safety and well-being. This includes both actual or threatened behavior towards you or your property, a member of your family or their property, or a member of your former partner's family or their property. We should explain that family violence is not just physical abuse or harm. It can also include psychological abuse or harm, forced sexual relations, forced isolation, controlling money, and dowry-related abuse. There are some special rules about how the Department of Home Affairs deal with specific visas in situations of family violence. They are called the family violence provisions. Temporary visa holders can apply for permanent residency if they have experienced family violence before they would have otherwise been entitled to apply for it, being 2 years after being with their sponsor, and they include partner subclasses 309-100, subclass 820 and 801, prospective marriage, the fiancé, subclass 300 visa, in limited circumstances, and dependent child subclass 445 and distinguished talent subclass 858. If you hold a temporary partner visa subclass 309 or 820 or a prospective marriage visa subclass 300 and experience family violence, your relationship has ended. There are provisions in Australia's migration laws to allow you to continue with your permanent partner visa application. The family violence provisions apply in such situations as when you have married your partner while on a prospective marriage visa and you have applied for the partner visa, or you are awaiting the outcome of your application for a temporary partner visa, or you have been granted a temporary partner visa, or you have entered Australia on a temporary partner visa. In the first instance, an applicant who has experienced family violence and their relationship with the perpetrator has ended should advise the Department of Home Affairs of their change of address by submitting a Form 929 and a form to inform immigration the change of circumstances, that is, that their relationship breakdown due to family violence has occurred, by submitting a Form 1022. It is important to note that if an applicant fails to advise the Department of Immigration of their change in circumstances, the department could refuse their permanent visa application without seeking further information. You will need to provide the Department of Home Affairs with evidence that there has been family violence. This evidence can be in various forms, including judicial evidence, and immigration must accept that family violence has occurred in this instance. Non-judicial evidence, they may accept that family violence has occurred, and independent expert evidence. In this case, immigration must accept their findings. It is at this point where matters become somewhat complex, and thus we strongly recommend you contact us for a direct face-to-face consultation to discuss your circumstances and whether you can evidence judicial, non-judicial evidence for a claim under the family violence provisions. If you do not have enough evidence for a claim under the family violence provisions, the Department of Home Affairs may ask for an independent expert to assess your case. The independent expert has special experience in situations of family violence and is not part of the Department of Home Affairs. The expert may need to meet with you, and they will make a recommendation about whether your evidence of family violence should be accepted. The Department of Home Affairs must follow that recommendation. Remember, if you or someone you know is in danger, call the police on 000. Police in Australia are safe and can be trusted. You can also contact the National Support Service for free for confidential counselling and information. You can call directly 1800 737 732. That concludes our video on family violence provisions. Remember, you may still be eligible for a permanent visa if your relationship with your partner breaks down. Whether you have evidence or not of that breakdown, we recommend that you contact us for a face-to-face consultation in our office or via Zoom. Alternatively, you can contact Willem directly on 0292621517 or email me directly willem@oli.com.au. Thank you for watching this video and goodbye for now.